And also with me here on the set, we still have MSNBC political analyst and Salon editor-at-large Joan Walsh and BuzzFeed legal editor Chris Geidner. Mr. Attorney General, I'll start with you. We've seen this happen at the state level before. I think of California and Proposition 8 out there, and Jerry Brown, when he was the Attorney General of California, basically saying, we're not going to defend this anymore. So there is a precedent at the state level. I wonder how you approach this, though. There's sort of a dilemma here as an Attorney General between maybe you disagree with the law, maybe it violates your own sense of what's right and wrong, but you're the Attorney General and your job is to defend the laws of your state. How do you strike that balance?
Well, you strike that balance every day in terms of what decisions you want to make. I mean, I was actually the president of all 50 of the attorneys general, and we would have debates all the time about issues that were relatively controversial, where maybe the Republicans would be more reticent to go after, say, big tobacco, or Democrats might be more willing to. And some of these are, they're policy decisions, but they all have legal underpinnings. I think the difference in this case that the Attorney General Holder was talking about is that attorneys general around the country should and probably do recognize that the marriage equality laws are unconstitutional. So this isn't sort of saying, well, you should pick and choose which ones you want to defend. You don't have to defend some laws, and you do have to defend other laws. You really don't have to defend a law that you know to be unconstitutional. I mean, Maryland, we've had this situation for a long time, and you just put a clip up from 2011. You know, I argued in favor of marriage equality back in 2008, and then ultimately wrote an opinion in 2010 recognizing out-of-state same-sex marriages in Maryland. And what's really particularly good is the law sometimes precedes the policy discussion. I mean, I watched your show earlier, and I thought one of the great things about this whole Arizona situation is how many people did not realize that right now it's actually legal for a restaurant or a place of public accommodation to discriminate against gay people, that it's actually legal under the Constitution of states and the federal government. So this dialogue is actually a positive one, I think.
But here's the flip side, and this is what I was sort of thinking about this week. Supporters of gay marriage, I think, presumably in some states where there's a marriage ban on the books, would cheer if the Attorney General of that state said, "Hey, I'm not going to defend this in court anymore." But I looked at this story from Wisconsin when Scott Walker first became governor, and he and the Republican Attorney General of the state, J.B. Van Hollen, announced that they were going to refuse to defend a lawsuit aimed at stopping a domestic partner registry in the state. And they basically said, we disagree with this law, even though the law is on the books. So it can cut both ways.
Yeah, I mean, it certainly can, but I think that that's part of our 50-state process, and the overwhelming majority of attorneys general who have been faced with this challenge especially since the Supreme Court's ruling in the Windsor case, have decided that this law, the Supreme Court, Justice Kennedy, in his opinion, sort of put the writing on the wall on this, and I'm not going to be the last Attorney General standing who's defending the law. I mean, in the case of Nevada, even the Republican governor, Brian Sandoval, decided after the Ninth Circuit moved to declare that sexual orientation should be subjected to more scrutiny by courts, that under that higher standard, even he couldn't come up with a way to defend the law, and so they've stopped defending it before the Ninth Circuit.
Yeah, that's right. That was news. I think that was just this week, right? Or in the last 2 weeks.
Yeah, everything's moving so quickly.
Right. You had Brian Sandoval in Nevada. The other news was out of Kentucky just this week, where a federal judge ordered that out-of-state gay marriages need to be recognized by the state. Now, Kentucky has a Democratic governor and a Democratic Attorney General, and the Democratic Attorney General of the state immediately moved for like a 90-day delay in this to decide, to get the state ready, but also to decide whether they're going to appeal this. So I guess there's
the judge gave them till March 20th.
Till March 20th, right? So there's some question there about what the intent of the Democratic Attorney General is right there. But Joan, how do you think about that balance between the Attorney General? Hey, it's the law of the state whether I like it or not.
Well, I do think that this is a really special realm where you see so much law going in the same direction. And Chris is right. You don't want to be the last Attorney General to go to the mat on something that is unconstitutional. But there's discretion, and there's always been discretion. You had a situation, for example, in Virginia, where the former Attorney General Ken Cuccinelli went to the mat to try to get his state's anti-sodomy laws back on the books when lower courts struck them down, which a lot of people perceived as a crazy fool's errand and running against the law. But they have that much discretion. So I don't think that Holder was saying. I think that Holder's comments that could be applied more broadly, but that he was directing them in a particular direction, and that limited to this issue, they make a lot of sense.
All right, I want to get the Attorney General back in here, but first we have to squeeze in one quick break. Back right after this.